Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Frank Pereira. A Supreme Court bench today rejected a petition seeking a court-monitored investigation into an alleged bribery racket that is said to have attempted to sway members of the judiciary. The petition was seen to have divided members of the top court last week when a constitutional bench passed a ruling saying only the Chief Justice was authorized to assign cases, overturning a fellow judge's order that would have sent the petition to a 5-judge bench. Justice Arun Mishra, the judge who authored the verdict, said that no judge was mentioned in the FIR filed by the CBI against the UP organization Prasad Educational Trust. The 3-judge bench said that the petition was contemptuous in nature, but it stopped short of initiating contempt proceedings. On this edition of The Big Picture, we will analyze how real is corruption in India's higher judiciary. Joining me on the program today are Justice R.S. Sodhi, former Delhi High Court judge; Soli Sorabjee, former Attorney General of India; Satya Prakash, legal editor of the Tribune; and Sandeep Mahapatra, advocate of the Supreme Court. Thank you to all my guests for joining me on this edition of The Big Picture. Mr. Sorabjee, I'd like to start with you first, of course, as a very eminent jurist. What are your thoughts on the medical college bribery case?
Well, I think the whole matter could have been handled more judiciously. I think everyone went a little overboard. Justice Chinmeshwar passed the order. Chief Justice reacted, rather overreacted. And then when the matter was heard, he passed a 3-judge bench was assigned to hear that matter, and it passed the order. Now, I can't understand why both the petitions, the CJAC petition and Kamini Jaiswal petition, could have been heard by the Chief Justice and other senior most judges. He would have been done so. This gives an impression in the public mind that there is division in the judiciary, that there is conflicting opinions about the judges. And that's not a healthy thing for democracy. Because if the litigant, the consumer of justice, does not have confidence in the independence of the judiciary because of whatever reasons, then I think it's a sad day for Indian democracy. I'm very upset personally, frankly, at what has happened. I think it would have been done in a more statesman-like manner. The Chief Justice could have appointed, of course he's a master of the roster, but in any case, instead of Chinmeshwar doing that, his order was also in a way not very correct, if I may say so, because it's an appropriate bench. But then advocates not allowing Prashant Bhushan to speak, shouting him down and wanting contempt proceedings against him. I think the whole thing now should be resolved in a statesman-like judicial manner, and the Chief Justice could have heard both the matters together.
Sure.
There would have been no need for all this fracas.
Sure. Justice Sodhi, you know, the drama that we've seen unfold before our eyes over the last few days, could all of that have been avoided? What do you think should have been done?
You know, it's very unfortunate what has happened. And of course, like Mr. Sorabjee, who has been in this court for years, has explained to you that there are things which could have been avoided. But at the same time, I am of the opinion that there is a great duty cast on the lawyers to behave themselves in court. They cannot misbehave or try and bully the court into a decision. Yes, I think Justice Chinmeshwar's order was not appropriate in the event that he could not have formulated the bench. But there was nothing stopping the Chief Justice from being magnanimous by adopting his order. However, it is always the prerogative of the Chief Justice, and he recused himself and made another bench. Said and done, you know, this kind of things can always be avoided, and must not appear as if the judiciary is is divided in itself, or each of them are casting any aspersion on the other. And see, the independence of the judiciary is very, very important. And also at the same time, lawyers must behave themselves. They cannot scream, shout, abuse judges, and or browbeat them, or try and show off that they are that they can get anything done from anybody by either blackmailing or by browbeating. This thing has to stop. There is some decorum, and that decorum must be followed. And of course, the judges have a very difficult task. Let me tell you, it's very easy to administer law, very difficult to administer justice, and very difficult to balance the two. In this case, I think the Chief Justice, like Mr. Sorabjee said, could have taken a better decision, but then the decision having taken as it has been taken, I find nothing wrong in it really.
Sure. Okay. Let me bring in Sandeep Mahapatra now. As far as this, was the bar wrong in the way it carried out its business? Aspersions were cast on senior Supreme Court judges. Do you believe that was the right way to go about it?
See, there has been a tendency for the last about 2-3 years, if I recollect correctly, and just before the present CJI was to be elevated, allegations were casted on him. An old case going back to the 80s, mid-80s was dug up, and aspersions were casted. So there is a background to the entire thing, and this has been going on, so to say. And the manner in which these cases were conducted, the situation would not have arisen if the second petition would not have been mentioned, because there were two petitions that were filed. One by a NGO and another by the member of the NGO who happens to be a Supreme Court advocate. And in the second case, the order was passed by Justice Chalameswar, constituting a 5-judges bench. And on the same day, Justice Sikri passed another order saying that yes, this has to be referred to a 5-judge bench, and he referred the matter to the Honorable the CJI. So the CJI was in a fix, so to say, and that has been dealt with in detail in today's judgment as to how to go about it. And as Justice Soli and Mr. Sorabjee has pointed out, it is the CJI's prerogative how to constitute the benches. And it is a convention, and it is enshrined in the Constitution itself under Article 145 and the Supreme Court rules which derives from 145. And the CJI has all the power to constitute the bench, and he constituted the bench, and the bench rightly passed an order. But what happened thereafter is that another request was made, an oral request was made, for recusal of one particular judge who happened to be in the bench which decided the hospital matters, the medical admission matters. And only an oral request was made, no application was filed, and that issue has also been dealt with. So the point that I am trying to make here is that you cannot be choosing your own judges. You cannot be filing petition after petition on the same ground, because these two petitions are on similar grounds, if not the same grounds, seeking the same prayer, and casting aspersions and pointing out that since something originated from the state of the present CJI, and therefore there could be some kind of an involvement, that is like making a wild allegation without any substantiation. And making that kind of an allegation against the CJI, who holds a constitutional post, is not called for. And those who made these kind of allegations need to introspect rather, that whether they are doing any good for the profession per se and to the judiciary. So these are questions that the profession, as lawyers also, we need to think, that while making allegations against judges, we need to be responsible, we need to be very cautious as to what kind of allegation is being made, because at the end of the day, it is the common people who are the litigant who are viewing us. Because as lawyers and judges, we go to the courts every day, but those litigants who come to court because of some exigencies, they should not be getting this impression that everybody, including the lawyers and judiciary, are corrupt, and therefore I cannot get anything. Because at the end of the day, judiciary is one institution in this country which has held its head high throughout emergency and otherwise also. So therefore that reputation has to be kept intact, and it is a joint duty, if I may use this word, of both the judiciary as well as the lawyers to protect that reputation, so that the country is well served, the litigants are well served.
Okay, fine. Let me begin, Satya Prakash. Now, the international media has taken keen interest in this particular case, and everyone has been reporting about it. I think the Guardian, it was, that ran a very interesting Justice Karnan saga that played out in May. Today you have this whole episode being played out in front of us.
Well, of course, judiciary is in a crisis, a rather deep crisis. There appears to be division within the Supreme Court judges. It emanates from the fact that there is lack of a mechanism to deal with situations like this. And what is the situation? Situation is there is a CBI case against a medical college, and there are allegations that a particular retired judge took bribe, or he tried to influence the Supreme Court judges who were hearing the case, and CJI happens to be one of the judges in that case. And this case, the two cases, as Sandeep has already mentioned, the two cases, both identical prayers, they wanted a Supreme Court monitored probe. The entire problem emanates from the fact that there are allegations against some unknown judges and some public functionaries who are not named in the CBI FIR. If there are some allegations, indirect allegations against the CJI, should CJI be hearing a particular case? Or should CJI be deciding who would be hearing a case? Should he be acting as the master of the roster in such cases also? That's the real question. Unfortunately, both the Supreme Court's Constitution Bench verdict and today's verdict, both the verdicts, they have skirted this issue. There is a lack of mechanism to deal with such situations, and situations remains the same. And that is why it is important to have a proper mechanism in place. I'm just suggesting it can be anything, or you can work out a different solution. The real issue is, if there are allegations against the CJI, the matter could have gone to the top 5 judges minus CJI. They could have collectively taken a decision, what is the issue and how it can be dealt with, whether it should be referred to a constitution bench or 3-judge bench or whatever, or whether there should be an SIT probe or not. They could have taken a decision that could have enhanced the credibility of the institution. Today, we are faced with a situation where it appears CJI is on the one side, the rest of the collegium is on the other side. Then some other 3 judges, he set up a bench. They have decided. In the process, the Supreme Court has lost the perception battle. The perception is being created as if there is something wrong in the Supreme Court and there is something fishy. That perception is going to damage the institution like anything.
Sure.
We should do something to arrest this kind of trend, because it is happening one after the other. If not arrested at the earliest, it will further damage the institution.
Mr. Sorabjee, I would like to bring you in on that point. Do you believe that irreparable damage has been done and it's going to be difficult to correct that damage going forward?
Well, damage has been done, but it's not irreparable. I'm sure the Supreme Court can find a way out, and in future it should appoint a more statesman-like approach. It would have been much better if the Chief Justice had even taken Chamleshwar as one of the judges to decide the matter. Yes, Chamleshwar is in a way not correct in referring the matter constituting a bench, but we are not on that. What I'm worried about is the confidence of the common man, of the consumer of justice, in the independence and impartiality of the court. Now, this sort of differences between the judges affects the common man's perception, in which case he won't go to a court of law, but will go to other people to settle his disputes. That, unfortunately, image has been damaged, but it's not irreparable. I'm sure the bench and the bar will find a proper statesman-like approach and come out of it. And
So,
this, if I may say so, this is a freak incident, and the less said the better about it, the better.
okay. Justice Sodhi, Mr. Sorabjee is calling it a freak incident, and he's saying that, there is an issue of perception as far as the higher judiciary is concerned. But just to widen the scope of the debate, how rampant is corruption in India's higher judiciary?
This is too loaded a question. However, let me tell you, this judiciary in the higher judiciary of this country is by far the greatest asset that this country has got. And I do not think allegations that fly just off the cuff should be taken seriously. It is very unfair for Mr. Prakash to say that the Chief Justice was under some kind of a cloud. There is no allegation except for the lawyers who are making this allegation. There is no allegation in the FIR, there is no allegation in the investigation. Please do not bring about this perception merely because some lawyers choose to malign a particular judge and thereafter try and browbeat him into submission. That should never be allowed. In any case, I am not very certain whether the image of the judiciary has been hurt. On the contrary, I think a firm decision taken by the Chief Justice in the interest of judiciary has helped to build its image. Just imagine if the Supreme Court judges would have buckled down under pressure. What would have been the impression? See, like I told you, doing justice is a very, very difficult thing, and balancing justice and law is even more. But at the same time, allegation is merely an allegation.
Sure.
Please do not confuse it with saying that the Chief Justice should not have heard it, since he is under a cloud. He is not under a cloud.
Justice
Please,
Sodhi,
for
argument's sake, let's look beyond this particular case and what has happened over the last few days. What if there are serious allegations of impropriety against some very senior judges who are looking into a particular case? What needs to be done then?
Yes, of course. You see, it depends from a case to case. Yes, if there are allegations and substantial allegations against any judge, be it senior or junior, doesn't matter, there has to be a mechanism which so far we do not know what it is. It is an in-house kind of a mechanism now, but we do not know what it is. There should be a quick disposal of the redressal by a body which either the Supreme Court invents itself, or like the National Judicial Commission or something of that sort should have come into place. Yes, I think resolving such issues must be above board, and it should not appear that we are brushing the thing under the carpet. That should not appear.
Sure. Okay. I think Satya Prakash was referring to a very mechanism of such a kind, to deal with issues precisely like this.
Yes.
Yeah, and your name was taken. Do you want to respond?
No, I'm saying what I referred to was the lack of absence of institutional mechanism to deal with such situations. In this case, of course, there is CJI's name or any judge's name is not there in the FIR. They are not under investigation. They cannot be because of certain protections given to them. But there are certain allegations and certain aspersions have been cast on the CJI, and that's not a question of, it's a matter of record. It was said right in front of the Supreme Court bench, 5 judges bench, and Mr. Bhushan stormed out of the court. It's widely reported. There is no question of not aspersions being against the CJI. He was right like this, told that so many things. I don't have to repeat that. So, but if there are certain allegations or aspersions cast on the CJI, should he be deciding the roster in such cases? That's the question, and there is a need to have proper mechanism to deal with such situations. That's my question, because we need institutional answers. Tomorrow, Mr. Justice Deepak Misra may not be there. Tomorrow, Mr. Justice Chalameswar may not be there, but the institution of the Supreme Court shall remain there.
Yes.
We need to have these institutional answers for that. We are searching for that.
Yeah, sure. Sandeep Mahapatra, what needs to be done really so as to ensure there is no scope of corruption left in our judiciary? What steps can we take going forward?
See, corruption in higher judiciary has been a topic which has been spoken about for years together. But there have been very few instances where it has been proved. The Constitution has given a mechanism of impeachment, which is a long overdrawn process, and in many cases we have seen that it doesn't work on the ground. So one of the area that we should look into is the kind of perks and other thing that has been given to the higher judiciary, whether it is as per the standard that behoves the higher judiciary. Number one is that. Number two is, I'll just give you an instance, and I read this somewhere. A judge had recounted about his experience, I think somewhere in India, that in days it was very easy for an advocate to get access to a judge's house. So one particular gentleman, he would go to the judge's house with a suitcase and just chit chat and come out, and after some time he'll go again and tell the judge that, look, I've forgotten my suitcase and I'll like to take that back. And the judge would innocently say that, why not? So later on it transpired that gentleman had apparently told somebody, saying that, look, I know this judge, you give me X amount of money, in front of your own eyes I'll go to this judge's house and I'll fix everything. So this is another kind of scenario which we are faced with. So whether or not higher judiciary to label the higher judiciary as corrupt, it will be wrong on our part to say that. If at all there has to be institutional mechanism, as Justice Soli had pointed out, and there has to be, so that's what NJSC tried to address. It is a different matter that it was struck down.
Yes, yes.
But now that we are, witnessing these kind of things where aspersons are being casted on judges, there has to be some mechanism to find out. And if somebody is just leveling aspersons for the sake of it, for the heck of it, then that person also needs to be taken to task.
Sure.
So that tomorrow it should not be a practice that I go to a judge and say that, look, I don't have any confidence and therefore you transfer my case. So it will become a routine process. So the entire judicial delivery system, judicial delivery system will come to a standstill, because I would have some allegation against Judge A, and then I'll go to B and make such allegations, and then I'll go to C, and in that process I'll lengthen the entire thing. And at the end of the day, it is the judicial delivery system which will suffer. And so when we are talking about credibility or developing credibility or enhancing the credibility of the judiciary, or for that matter, the judicial delivery system, which includes lawyers also, we need to think all this through. Rather than in a piecemeal manner, there has to be a thought process which will fix all these things. This is our experience in the last 60 years.
Sure. Mr. Sorabjee, you've heard what all the other panelists have said, so as to ensure more transparency, and we need some kind of a mechanism. What are your thoughts on what needs to be done going forward?
Well, actually, main thing is you have the mechanism as present, more in-house thing. What I want to tell you is, please understand one thing. If you don't want a particular judge, you make allegations and ask him to recuse himself. That'd be really leading to, if I may say so, blackmail by lawyers. The whole idea is the judiciary must, in a way, act which inspires confidence in the consumer of justice. How was anyone interested in particular allegation against a particular judge? If there is a black sheep amongst the judges, of course they'll be removed. But the question is not anyone thinking, no, for that purpose, this judge must recuse himself, or that judge must not hear. There will be no end to it. There must be confidence in our Chief Justice, in our justice system. And I don't think, I think here everyone has gone a little beyond the bend. The laws also shouted down Prashant Bhushan. I don't approve of that, because after all, he didn't have any axe to grind except his mental makeup. He doesn't think any judgment is erroneous. He always thinks it is corrupt. But that's his mental makeup. But he doesn't got anything against the judiciary. So it has to be sorted out by the judiciary. Let them introspect and really find out a method which is more or less unanimous, which has the consent of all the judges, and it does not give the impression of a rift between them. Because
Sure.
if that impression is created, there'll be a rift, there'll be a dent in the public confidence in the independence and neutrality of judiciary, which is the last thing should happen in our country.
Right. Justice
You can
Sodhi.
make allegations, but by and large, let me tell you,
Yeah.
the example of that person going with a suitcase and all that, that's an extreme, absurd example.
Okay. Okay.
Our high judiciary, I dare say, I've been in the profession for several years, by and large are really honest, upright, conscientious, hard-working judges. One or two black sheep does not mean that the judiciary as a whole can be condemned as corrupt.
Okay.
Or can be looked upon as corrupt.
Fair enough.
That
Mr.
we are
Sorabjee,
very
I'm sorry to
wrong
cut you
impression
short. Running out of time here. In 30 seconds, Justice Sodhi, close the show for us with your concluding remarks.
Like I said, the judiciary, there's nothing wrong with the judiciary. Every judge, all of us have confronted with such kind of bullying advocates in their courts. They have to be put right. But at the same time, the impression must not be given as if there is a conflict in the judiciary itself, and that some judges think the others are not above board, or they have some doubts in their integrities. This cannot be tolerated at all.
All right.
Yes, a mechanism must be found if there is such a problem, and but at the same time, allegations allegations are flying off the cuff every day.
Sure.
You don't want a particular judge to hear a case, just accuse him for something or the other, and the poor man just recuses. This is not done, and I'm absolutely against such behavior.
All right, on that note, then we'll have to call it a wrap on this edition of The Big Picture. I'd like to thank all my guests for joining me on the program and putting things into perspective for us. That's all the time we have today. See you again next time.